Government agencies in New Jersey can deny access to public records by neither confirming nor denying the records exist. That's what an appeals court ruled in a case that's likely to go to the state Supreme Court. Here to talk about it is Bruce Rosen, partner in McCusker, Anselmi, Rosen, and Carvelli, and the outside counsel for NJTV. Bruce, welcome to the broadcast.
Nice to see you.
The facts here: a reporter was asking for records, 911 transcript, 911 recording, and others, of a 911 call to authorities in Bergen County of a priest who hadn't been charged with anything or convicted of a crime. What's your reaction to this ruling?
To me, it's an unnecessary narrowing of OPRA, which provides for a presumption of access. It also creates an exemption that did not exist before. As a matter of fact, it creates an exemption out of whole cloth, I believe, that is, you wouldn't see this exemption anywhere else in the United States in a state public access law except in Indiana, and the court itself mentions that. It's really a bad omen, and it comes from an appellate division that has been openly antagonistic toward OPRA over the past year.
I'm going to talk to you more about that, but first, the prosecutor's office in this case, Bergen County, argued that, look, here's someone who is, we don't know if the person is innocent or guilty. There's a presumption of innocence in this particular case. If you release this information and this person hasn't been charged with a crime, and eventually this person could be innocent and proven not guilty at trial, then you've damaged this person's reputation.
That's a fallacy to me, because the person's not being charged, not being charged as an unindicted co-conspirator. It's just someone that was a subject of a look-see by the prosecutor's office. It's, for some reason, there's some information there. And what the court said is, in cases like that, we're going to create an exemption so that their privacy is protected. And what the court's essentially said is, we're going right to the balancing test. And if privacy is a big issue, we're going to say that you can balance your privacy in favor of the individual. It cuts off all sorts of access to all sorts of important information, and it really runs against the reasons why OPRA exists, and it undermines OPRA. And someone needs to correct this. I hope it's the state Supreme Court, but it might have to be the legislature, and that actually might have to wait until after Governor Christie is out of office.
Will more government agencies use this precedent as a reason to deny access to public records, to deny access to transparency?
It will be mostly investigative agencies and police that will have to meet the criteria set out in this appellate division decision, assuming it's not reversed by the Supreme Court.
What's the criteria?
So the criteria is that the agency has to say that there is an exemption that covers this, and the court has to be able to look at that exemption to determine whether it really exists. In this particular case, the exemption wasn't clear-cut, and the court sort of created one by pulling in all of this various law and looking for references in what's called dicta, which is parts of cases that don't go to the holding. They are basically pulling in all this different language from all over and creating a new exemption.
But you're seeing in your practice, though, that this appeals court in this particular state, this is not new. You've seen a trend in other rulings going towards something like this.
In the last year, since July 2015, where there's a Lyndhurst decision that was pretty serious, that went against I thought the weight of OPRA, there have been at least another 5 decisions, including this one, by various panels. It's not by the same 3 judges, and there's many, many different panels in the appellate division, but they all seem antagonistic in some way or another to either OPRA or the idea of a presumption of a release of information.
How does this get reversed? How does this get changed? How do we get more access?
Well, the legislature had been looking at changes to OPRA, and those changes seem to have died on the vine. The problem is that Governor Christie's administration has been antagonistic toward release of a lot of information, including a lot of this Bridgegate information, and there's just an enormous backlog in the appellate division of these type of cases. And I know I have one about whether you can even Oprah, whether you can look at other people's requests to the state, and the trial court judge says, yes, absolutely, that's the way it's done on the federal level, and the appellate divisions, it's been over a year, we still don't have a date for an argument. But the only way that this is going to get fixed is if the Supreme Court goes back to the basics of Oprah and says, wait, the definition of Oprah is everything is open unless it's covered by these exemptions, and we're not going to make up exemptions.
Rich Rosen, thank you.
Thank you.